Good morning, everyone. We're just going to wait for some participants to join. But whilst we do that, let me introduce the panelists. We have myself, I'm the managing partner of Schindler's Attorneys. We have Derek from IQ. We have my partner, Dean, who's also a partner at Schindler's Attorneys. We have Ian, who is the managing director of Engaged. And we have Peter Gordon, who's also from Engaged, and Dom from Schindler's. So the format today will take the form of a Q&A. I must mention that if you want a step-by-step lecture video on the Act, going through the provisions and explaining them in more detail, that video is on the Schindler's Attorneys webpage. So please, have a look at that. And importantly, in relation to today, please make a point of asking questions. We find that it's far more interesting, it's far more enjoyable if we actually deal with the specifics of your business. If, however, this is an open forum, you don't want to deal with the specifics of your business, bear in mind that the COBRA ecosystem provides, at a pro bono basis, legal advice with your team, so we can arrange a one-on-one or a team of professionals from COBRA to consult. And that includes issues such as labor. So it's not just business rescue, it is any law or experience that we have in relation to rehabilitating businesses. So we'll kick off. I'll primarily be directing questions to the Engaged guys because they are the business rescue practitioners. They're the guys on the ground. Attorneys work very closely with business rescue practitioners because they need legal advice, particularly when a business rescue becomes adversarial, which often is the case. But I must mention, and importantly, I don't think we're going to find as many disputes because we know why people are not paying. And importantly, the stigma of business rescue has gone, and a lot of people are concerned around the stigma. The stigma has gone, but COBRA's main aim is to keep you out of business rescue, and we'll go through that. So I'll kick off. Ian, a business has to be in financial distress. What's meant by that?
Maurice, thank you. Financial distress is defined as a reasonable likelihood that the business won't be able to meet its payment obligations in the normal course of business during the ensuing 6 months. So if a business, and that would basically mean that most, or probably most businesses at this stage are in distress, are in financial distress because of the inherent uncertainty and inherent likelihood that a lot of them won't be able to meet their obligations in the next 6 months. So that is what is defined as financial distress. And if a company is in financial distress, it has an obligation to consider business rescue and for the board to vote as to whether it should be put into business rescue or not.
Yeah, I think that's an important aspect. And if they don't, and if you don't, if the board decides to resolve that business rescue is not appropriate, then it has to notify the shareholders and, well, the affected parties, creditors and employees. And they have to set out why, despite the business being in financial distress, it was not placed into business rescue. Normally, that's very, very difficult to come up with reasons. But in this context, it's quite easy. You can say, look, we're going to the COBRA environment. They're going to mediate payment arrangements, and we can avoid business rescue that way. So you have an obligation in terms of our law as directors to put it to a vote, but that vote can be a simple round robin saying, no, we've decided to go into the COBRA environment. If you want a resolution that says as much, and the notice to send to your employees and to your creditors, let us know. We also have notices which invite creditors into the ecosystem, and that's part of the alternatives that that one can raise as a ground for not going into business rescue. So bear that in mind. You have to put it to a vote. Was there anything further? Sorry, I interrupted you, Ian.
No, that's fine, Maurice. Let me just add to it that us as Engaged, prior to starting the COBRA initiative with IQ Business and all the other partners, Schindlers and Engage have worked together extensively, and our modus operandi has always been to not put a company into business rescue unless it really is essential. You know, if there's creditors banging down the door and not prepared to negotiate outside of business rescue, but we prefer to keep it outside of business rescue as long as possible. So
I think in this climate it's going to be far easier, because creditors are going to be more reasonable. They're not going to be as aggressive.
Absolutely.
They can't point fingers. They can only point fingers to nature.
Yes.
So tell us about your role. As a
the role of the business rescue practitioner is basically to come in once a business rescue. The board normally appoints the business rescue practitioner, so the directors will voluntarily put the company into business rescue and then appoint the business rescue practitioner. That's how it works 99% of the time. What the other 1% of the time is where a creditor applies to court to put the company into business rescue and to have a business rescue practitioner of their choice nominated. But 99% of the time, it's a voluntary decision by the board to put the company into rescue, and then they can appoint the practitioner who they want to appoint. The role of the practitioner is that he takes ultimate control of the board of directors. The board of directors has to work with the business rescue practitioner, has to ultimately report to the business rescue practitioner. This is why it is so important to choose the right business rescue practitioner. I'm sure everybody in the audience has probably heard some bad business rescue stories, and you know, I often say that business rescue does actually have a bad reputation, and for good reason. Unfortunately, in our profession, there's a lot of practitioners who are out there practicing who are not necessarily qualified to be with a skill set to be practicing as business rescue practitioners, and unfortunately, some of them have done some dodgy things along the way, and yeah, unfortunately, it's an industry which is fairly immature. It's only been around since the Companies Act of 2008 was promulgated, and first business rescues took place in 2011. So it's still a young industry. There's still a lot of regulation in the industry that has to happen. So until that happens, you know, you'll find there will be some bad business rescue stories. But everybody in our team, in the COBRA initiative, in the collaboration, everybody who's a business rescue practitioner has impeccable track record and impeccable credentials. So you can feel rest assured that you are in the right hands in the COBRA initiative.
Yeah.
Quickly, sorry, Maurice. Yeah, the role of the business rescue practitioner. So the board reports to him, and it has to be the business rescue practitioner has to be somebody who will work with the board. We often say that you know, we will never know a company's business as well as the board of directors, or as well as the person who founded that business. We will never have the relationships that you have with your customers and with your suppliers and with the public at large. So we are not there to come in and kick the CEO out of his seat and to take control of the business. We are there to work with you, to guide you through the process, to hopefully get you out of the process at the end of the day, and to help you plug the gaps from an operational perspective where your company might be lacking. And that's how our operation normally works.
Yeah, and I'll give an example. You know, I raised Camps Bay just so the audience can, that Camps Bay restaurant example, so the audience can understand how simple it can be. And the business rescue that we did, we placed the company into business rescue because it was distressed. We went to the landlord, opened up the books, said, look, this is the situation. The economy has changed. The landlord was reasonable, realized that a remission of rental was the lesser of the two evils, and the one evil obviously being a liquidation, and the landlord obliged, pulled out a business rescue, and that was it. It was very, very simple, and the relationship there did not require the business rescue practitioner to actually run the business. So just when is liquidation more appropriate, Dan?
Liquidation is more appropriate when there are there's certain powers that a liquidator has that a business rescue practitioner doesn't have. powers such as investigating fraud, powers such as investigating voidable dispositions and reversing voidable dispositions. Voidable disposition is generally is basically an asset of the company has been disposed of prior to liquidation, or during liquidation even, and the creditors feel that it was disposed of at a value below its actual market value, which to the prejudice of creditors or affected persons. So the liquidator has the power to reverse that transaction. A business rescue practitioner doesn't. So if there's a risk of a big risk of fraud or avoidable dispositions, then liquidation is sometimes a better option than business rescue. Typically, as business rescue practitioners, we like to be able to work with the CEOs of the company. I said yesterday, we've sometimes the times that we've turned away from business rescues and not taken on business rescues, we're dealing with the term I used was reprehensible individuals as directors, and that's just the makings of a disaster right from the very beginning, because we know we're going to bash heads with the directors at all times, and in those cases it's normally best just to put the company into liquidation.
No, absolutely. There's the Act does provide that business rescue remains appropriate if there's a better return for creditors as a result of the rescue. And you'll find that an orderly wind down, so an orderly liquidation within business rescue may in fact be appropriate, and often is, particularly when the asset value is really high, because liquidators operate on a percentage. It's either 10, 6, or 3%, whereas business rescue practitioners work on an hourly rate. So hypothetically, if a company only has, let's say, listed shares as assets, and this in fact is a case in point, it's a case in point that it related to an executrix who also operates on a percentage. Now, all the executrix had to do, so in the case of a business rescue practitioner, is sell the assets. The sale of the assets is one phone call to a broker, and then it gets sold, and then there's the LND account. Now, what would you rather do? Pay a fixed percentage in relation to 100 million rands in shares, let's say, or pay a business rescue practitioner 5 hours work for that? So those are the considerations. Even an orderly wind down may attract a rescue versus a liquidation as being more appropriate. Through these lectures, there are three themes. I'm just addressing the panelists that I think are very, very important to the audience. Three aspects of business rescue. And I think we go through them now. We may be jumping around a bit, but I'd like to go through them now so that the audience can begin thinking about these three aspects, and the audience can begin asking questions because they're so important. We've also found that the most interest has actually been directed in relation to these. And these are the moratorium, what in fact happens during business rescue, and what's tied in with that is the question of contracts and the suspension of obligations in terms of contracts. Then there's the question of post-commencement finance, which is important because of the order of preference that it gives to the lenders. And then the third is employees. Employees, what are their rights, what are their obligations, and what happens with employees? So I think let's start with employees, because a lot of people are saying, well, the employees have not done anything wrong. All of a sudden there's an operational need to reduce expenses, and here are these employees. Can the business rescue practitioner deal with them any differently than if the company was out of business rescue? Peter?
Maurice, thanks. No, the excuse me, Chapter 6 specifically says employee contracts remain unchanged. But let's remember that in business rescue, you're trying to run the business. So the business in rescue can still go through a downsizing process by affecting employees in terms of the Labour Act and doing redundancies. And obviously, if hiring and firing is required as well, that is also, the practitioner is also able to do that. So that's in terms of the law. The one thing we must remember with employees is that they are continually being creditors of the company, because the company owes them money after the first day after they've been paid for work performed, as well as accrued leave, bonuses, etc. So they are creditors in the process, and therefore are classed as affected people. So they have to be advised of their rights and obligations, and how this, what I'm explaining now, how this works and affects the employees in a formal meeting in terms of the Act. But yeah, generally, look, obviously in rescue, employees and the unions have to take that into account, and possibly not be so aggressive in exercising their rights. So there is an opportunity to negotiate terms with employers whereby you could reduce salaries across the board and pick it up at a later date or not, but no different from how it would be outside of rescue, of how you have to treat employees vis-a-vis their contracts of employment.
Yeah, sure. So, I mean, there's also the aspects, I'll jump in from a legal perspective, and that is the question of retrenchments and the consultative process as is required by Section 189 of the Companies Act. Now, normally you have to spend some time consulting with employees to consult on what's set out in Section 189(1), the requirements which include the reasons for the proposed dismissals. Now, you know, in this climate, not much time is going to be spent consulting on the reasons. We all know the reasons, and the reasons are common cause. So a view has been adopted by Labour attorneys that the consultative process will, in all probability, it will be appropriate even if it's relatively short. The expenses have to be cut as soon as possible for some businesses, particularly if you're in the entertainment industry. So then the question arises, what does one do if the business cannot afford the severance pay? And particularly with employees who've been around for years. And that's actually been a struggle. And that's where it's important to try and negotiate with the employees and have them understand that whilst they may be retrenched, there will be an obligation to re-employ them once the business ramps up once again. And that them taking potentially a knock on severance pay may result in them saving the business, which then obviously gives rise concomitantly with them having a job.
Maurice, we've had a couple of extraordinary instances where there have been retrenchments and the company simply hasn't had money to pay the retrenchment pay or pay the severance pay. And the company's only been able to pay it after several months when an asset has been sold or whatever the case may be. So, yeah, the power is there for the business rescue practitioner to act in the normal sense of Section 189, to retrench the employees, but in certain extreme severe cases, there may not be enough money to pay the severance packages, but yes, that can be delayed in the business rescue process. Of course, there's the risk that employee, and of course nobody wants to do that. You know, nobody wants to deny a retrenched employee their severance pay, but sometimes there just is no money to pay. The risk is obviously there that the employee can go to the CCMA and get an enforcement order against the company. And this is an interesting one because I'm not sure it's been tested in court, but the moratorium against enforcement action against the company does not preclude enforcement action by the CCMA.
Whilst you're on the topic, do you want to discuss the moratorium?
Yes, let's do that. So the moratorium is basically prevents legal action against the company, and that includes enforcement action. So any legal actions that are in place against the company from a creditor or whatever the case may be are suspended at the time that the company goes into business rescue. And that includes enforcement action. So enforcement action is typically where the sheriff will come and attach property or assets of the company. So if the sheriff is due to come and take away the assets of the company on the 3rd of the month, and the company goes into rescue on the 2nd of the month, then the sheriff is no longer by law entitled to remove those assets. So that's the extent of the protection that business rescue actually affords to these businesses.
And yeah, what's important with the moratorium is it doesn't necessarily apply to contracts that have not been suspended by the business rescue practitioner. So it's important for you to have a list of all the creditors to give to the business rescue practitioner. Creditors where the creditors are counterparties to contracts, have that list so that the business rescue practitioner can immediately write to them and suspend the contracts, so that you don't find yourself in a situation as in a judgment by Borochovitz, where the business rescue practitioner, who clearly wasn't experienced, did not send the notice out, and that resulted in a termination of the lease because the lease carried on. The moment the termination of the lease had been effected, there was no reason. The company was in essence squatting, and the court found that despite the company in business rescue, an eviction was still appropriate. So that suspension is one of the most important things to bear in mind, particularly if you're going to be approaching a business rescue practitioner and you doubt whether they're experienced. Just let them know. I've got a question which ties in with approaching a business rescue practitioner. Obviously, you don't have to go through COBRA. It begs the question, why would you not go through COBRA? Because COBRA's got the pro bono initiative. Well, let's tie into this. It says, can any company, no matter size or amount of directors or yearly income of the company, approach COBRA? The answer to that is a big yes. The question that arises, and will only be gleaned from the business rescue process and whether the company survives, is whether a particular company passes the means test. And the means test is a test that's promulgated by the Law Society, and one only qualifies for pro bono if, for instance, your income falls below a particular threshold. COBRA provides pro bono services regardless of the means test when it comes to the legal advice, when it comes to consultations with company teams, when it comes to placing the company into business rescue, and in circumstances where the business rescue fails, the conversion to a liquidation will be dealt with on a pro bono basis. That's a high court application that you normally pay about 30,000 rands for. That'll be dealt with by Schindler's on a pro bono basis. Where pro bono may not kick in is in relation to the actual business rescue practitioner's fees and disbursements, because those fees and disbursements, there wouldn't be a justification to not pay them if after the business rescue you have, let's say, 5 million in the kitty, because there was money and all that the business rescue was required was for cash flow, and that was it. If, however, the professional fees come between a successful business rescue and a liquidation, was a successful business rescue rather, then the matter is handled pro bono from beginning to end, because you needed it and you don't want the professional fees to break the bank to a point where it has to go into liquidation. Whilst we're on employees, what we found, I think that dealt with the pro bono, and it also dealt with the fact that any company can go into business rescue. Just on the employees, what we found is a lot of people are desperate, and they are directors and shareholders are putting funds into a business with a view to paying their employees. Now, obviously that's important because you want to retain the employees, but our advice to you is, in those circumstances, if any money is going to go into the business, only do so post business rescue, because there's this notion of post commencement finance, PCF, and PCF gives you super preference, which puts you above the banks and puts you above the South African Revenue Services in relation to being paid back on a liquidation or in terms of the business rescue. I think, let me just hand over to Peter, who can deal with that on a practical level. Peter?
Maurice, thanks. Yes, as you say, it's super preference. So what does all this mean? Bearing in mind the business rescue practitioner has unfettered access to all the assets of the company. So anybody that has security pre the rescue date, that doesn't go away. As Maurice rightly said, you need to decide which contract you're suspending. If you've got onerous contracts, you can go to court to have them set aside. But that aside, contracts remain in place, and security is unaffected other than the holder of the security can't exercise it. So what that means is after rescue's been after filing for rescue, the practitioner can use any of the assets of the company to secure new funding, which is a sensible thing to do. I mean, there's an intriguing conundrum here that you could negotiate with a bank to pay them out that was secured prior rescue by replacing it with new banking facilities, possibly with a new financier with the same security, but that financier suddenly is super preferent. So there are ways that you can do that. There are not many providers of distressed debt or people that would take on distressed debt in South Africa, unlike the States and Europe, where it's a fairly vibrant industry. Here, there are a few. We're in touch with those individuals or those companies. And the idea there is that we try and find the security for the funder, work out obviously essentially how much is required for PCF, and then establish new security in the business. The other important provider of PCF is obviously the banks. It's quite critical that the practitioner is in close contact with the banks. And depending on how far down the company's gone on its route before it goes into rescue, you might find different people in the bank dealing with the particular company. If it's the lawyers in the bank, I say to potential rescue cases that it's almost too late, because the lawyers in the banks, all they're interested in doing is recovering the money under their security. So you're not going to be able to negotiate with them that easily. The banks all the big major banks have now got teams of people that are specifically there to assist with turnarounds. That doesn't mean that they're going to be a walkover. I literally got a letter this morning from one of the major banks where they've refused to do a cutback on an overdraft facility at $500,000 a month, and they're going to continue notwithstanding the crisis that the globe finds itself in. So sometimes the banks are going to be difficult, but generally the people in the banks that are in the turnaround sections are used to working in distressed environments. And so the opportunity to raise additional funding from the bank, or not even additional funding, merely to get the bank to unfreeze the facilities, because what a bank will do is say, you have an overdraft, it's on immediate call, there's an item of default here, you've gone into business rescue, we're freezing your facility. And if the facility in the bank is frozen, how are you going to continue trading, because you need access to funds to pay supplier staff, et cetera, and importantly, to receive monies from your customers. So it is quite critical that your practitioner has a good relationship with these teams and can ensure that facilities aren't frozen and continue. The critical thing here is each case comes with its own complications and its own merits. And it's important for the practitioner to understand those fairly rapidly, to understand where the pressure points are. And I can tell you now, the bank is definitely one of them. Between Ian and myself, we will always approach the bank as we're appointed, literally the day that we're appointed. We will advise the bank and try and set up a meeting as quickly as possible, then just to agree with them how we go forward.
On that score, just your obligations to notify creditors and meet with creditors and employees and the time periods?
You see, within 10 days of the practitioner's appointment, I was going to chip in earlier, but I'll say it now. One of the things that people must remember, unlike a liquidation, is the business rescue practitioner should be a businessman or woman. It's a person that understands the cut and thrust, especially in the small to medium markets, the cut and thrust of business of, dare I say, robbing Peter to pay Paul. It's how to work in a situation where the cash flows are tight. The law of it, though, the law that governs rescue is obviously quite critical, because if you miss and constantly miss the deadlines that are set, and it's all time driven, then there is an opportunity for a creditor to apply to the courts to say that the business rescuers should be null and void. For example, if your resolutions weren't properly done, properly filed, sworn affidavit filed, if that wasn't properly done, then a creditor can go justifiably to court and say, this company is not in rescue, so please can we have a liquidation application order against them. 10 days after the business rescue practitioner's appointed, he's got to have 2 meetings, a 148 and a 149, section 148 and section 149 meeting with the creditors. 148 is the staff. As I said earlier, the staff are creditors by the mere fact that they are working for you. And the staff need to be informed introduced obviously to the practitioner, informed of what the initial plan is and whether the practitioner believes that this company can be rescued. And then the next meeting, the 149 meeting, is with the creditors. And there's really only 3 things that, in terms of the law, that the practitioner has to do. Firstly, he's got to explain, once he's introduced himself, he's got to explain the process as we're doing at the moment. He then has to explain the fact that the creditors may form a creditors committee. It's really making communication easier for the practitioner. If you've got 5,000 creditors, it would be a nightmare if 5,000 people are bombarding the practitioner with questions every day. So the creditors they don't have to, they can form a committee, and that committee then is the main contact point between the practitioner and the creditors. Doesn't affect the individual creditors' rights at all. Those always remain in place, and even if they've agreed to the committee, they can still come into the practitioner with their queries. The third thing is and importantly, the practitioner has to make a statement, bear in mind this is 10 days after he's been appointed, to state that the company he believes can be rescued. And indeed, after a time period, if the business rescue plan hasn't been published and voted on, he has to do a monthly report to all the creditors and shareholders and what we call affected people. And in that report, each time he has to make that statement that this company is still able to be rescued, or most importantly, that by going through a rescue process, the creditors will get a better dividend than they would under a liquidation scenario. But it's the formal part of the communication tool, but it is one of the cornerstones of business rescue, making sure, and any company that's in distress, whether you're in business rescue or not, and there's a lot of companies in that position at the moment, is it's critical to communicate with your creditors to let them know where you stand, because the worst is when the banks or the creditors haven't heard from you, they've had no money from you, they've sent a number of letters demanding money and they haven't heard and they don't know what's going on. And if you keep people informed, and as Maurice said earlier, certainly in the current environment, if you're keeping your suppliers informed, they're more likely to be sympathetic as to your problems.
Thanks, Peter. Just on the question of creditors, the voting on the plan, and the different categories of creditors.
Sure. Any plan that we put together, there will be an Excel spreadsheet, needless to say, list of creditors, the amount owed. It'll be split between what's been adopted, what's been acknowledged, and that is still in dispute. The amounts that are in dispute, we try really hard before and after the business rescue plan's published to resolve any issues and get them into the adopted position. And once we've approved the creditors, that value, by value, has a vote. So you've got 100 Rand of creditors. By value, you need 75 Rand to say yes to the vote, 75%. We then separate creditors between 2 important categories, those that are independent and those that are non-independent. Non-independents would be shareholder loans, directors' loans, family loans into the business, intercompany loans into the business. So anything that is connected to the business is non-independent. Their vote is diluted. So in simple terms, you need 75%. Of that 75%, 50%, or rather 2/3 of it, has to be independent. And once you've got that, then, and you've published your plan, 10 days after you publish your plan, there is this vote. It's called a Section 151 meeting. And the vote on the plan, or you present the plan and then you take the vote. And if you get 75%, the plan is then considered adopted. And that really is the master plan of how you're going to turn this business around. And whether that's a turnaround that you're planning on handing back a healthy, profitable business back to the owners, or a controlled wind down of the assets of the business in order to extricate better value under less pressurized circumstances that would be the case in liquidation, you then carry out your plan as agreed by the creditors.
What if they don't vote in favor of the plan?
This is a fairly formal process. I mean, first thing, obviously, it's like the politicians say, you never put a motion before Parliament unless you've done behind the scenes negotiations with the parliamentarians. It's exactly the same. We would negotiate and meet with certainly the main creditors to make sure that the plan broadly meets their requirements, so that when we do go to the meeting, also to say the meeting, who attends, all creditors are invited, that they don't have to attend in person. They can send a proxy, often to the practitioner, or you'll have their lawyers turning up, or you have a group of creditors that team up together. So it's voting in person or by proxy. If for whatever reason you fail to get that vote, we think of Studdefords where they could not get their plan through the creditors, and then he went into liquidation. So what the practitioner does is he takes a vote, he then reports back to the meeting at the same meeting, having counted up the votes, that the plan has not been adopted. The creditors or he can then immediately suggest amendments to the plan as presented. If it's a fairly simple amendment, if he's got a feeling out of the meeting that the creditors or a large body of the creditors are unhappy with one particular item, he can present that as an amendment to the plan and then take the vote again. If that fails, he then has an opportunity to say, I'm going to try harder. And he's got a time period in which he can go vamp the plan and represent it. You go through the same loop again. If at that point in the first meeting he remains silent, any creditor can step forward. He has the right to do it first. The creditor has the second right to step forward and say they want to present a plan. They should at the meeting give an indication of what that is. If the practitioner believes that that is a potential way of solving the problem, he can agree to allow it in. If he believes it has no hope in hell because it only protects a small group of creditors, for example, this is not unusual, then he can reject the proposal. But obviously you're walking on a tightrope at this stage, because really what you want to do is get the plan approved. If the creditors have suggested an alternative, same again, the practitioner goes away, includes that in the plan, and then republishes, and then takes a vote. If, hopefully not, but if at that stage it still fails, then, I mean, the Act is not 100% clear on that, but as practitioners, we take the reading as such that the practitioner is then obligated to put it into liquidation. Because the company's in rescue, you cannot get your plan approved. You can't take it out of rescue because there's no point in doing so. The company is insolvent, unable to continue trading. So really the only option is to put it into liquidation. And as Maurice, as you covered earlier, that's quite a sensitive point for practitioners, because you often find the case where a company is in dire straits and eventually does fail, and the plan doesn't succeed or the plan's not voted on. The practitioner is then obligated to put it into liquidation, which means he or she has to approach the courts with that liquidation application. And there's a cost element in there. So what the practitioners will often do in the early days of a rescue is require the company to place money on deposit, normally in trust with the lawyers, to cover that eventuality. And I'm obviously now talking about the smaller businesses. And let's also say that when you're applying to court for liquidation, Maurice gave a figure of 30, 40,000. That's assuming it's an unopposed case. If it's opposed, this thing can become quite an expensive exercise. So the practitioner protects himself by having that money available to him in a pool. Now, if you're a small business, for goodness sake, where are you going to get 30,000 to suddenly stick into a trust account? So the COBRA option is fantastic from that point of view, but it's also a thing to bear in mind. And, I sit on a body of practitioners at the Institute of Accountants, and it's often a point raised, how do we deal with this? So yeah, it's unfortunately liquidation is the end result.
And just well, any of the engaged guys, have you ever had it where the plan has been approved, but during the implementation of the plan, you note that it's not going to work? Let's say you've missed something. What then? Does one resubmit a plan? Does one what does one do if one sees that the actual plan that was voted on is just not working?
You've got a choice. You've got a choice, Maurice. Peter, sorry, feel free to jump in. I'll talk quickly. You've got a choice. You can either amend the plan and put it forward to creditors to vote on, bearing in mind that you, at all times, you have to be able to achieve a better return than you would achieve in a liquidation scenario. So you can amend the plan. You can put it forward to creditors to vote on. If they vote in favor of the amendments, for example, the case may be that the business rescue plan has now, you failed to sell an asset, or you sold it for a much lower value than you expected, or the operational profits of the company during the business rescue period were turned out to be much less than the original business rescue plan predicted. Then, and now this is going to result in creditors receiving a lower return than they would have gotten as per the original plan. You can put it forward to creditors to vote on, and typically the same rules would apply as applied to the normal, to the original Section 152 meeting. So 50% of independent creditors would essentially need to approve the changes. Or, of course, if it's not working, you can put it into liquidation. Yes, we've had instances of both. Fortunately, we haven't had many that haven't worked and where we've had to liquidate. There's only been a couple. But we've had instances where we've had to amend the plan and get the creditors' vote to approve the amendments. Peter?
Well, Maurice, look, I dealt with an interesting one back end of last year. Mining contractors, the assets were sort of gauged at around 30 million. They told me their creditors were about 15 million. I've got 2 days after being approached, or 3 days, to decide whether I want to take the appointment or not. Obviously, a practitioner can turn an appointment down. So I said yes. I thought, the equipment we should surely be able to sell for even a knockdown value in order to pay the creditors. The mining contract that they had wasn't under their control, so there was little point in continuing with the business. I then started, and this is an important point, I covered it a bit with the salaries. You sit down with business owners and you say, okay, how much do you owe? And they say 15 million. And then you say, what about the staff, accrued leave, redundancy pay? Oh, okay, well, that's another 3 million. And so it went. There were old shareholder loans that they hadn't taken into account. There were some directors' loans. There were some suppliers that they'd forgotten about because they hadn't paid them for donkey's years, not that it had been prescribed yet. And what I ended up was with not even 15 million of assets and about just shy of 100 million of liabilities. It was an extreme case. It didn't take long. It took 24 hours to call the meeting and advise the creditors that I was going to apply for the liquidation of the company. So that was a quick one. Where you've got, and I think it's important to state, what the practitioner doesn't want to happen, even though the practitioner is obligated to obviously abide by Chapter 6 and the general law. And when I say general law, I'm not only talking about the Companies Act. The practitioner should have a knowledge of all the laws, hence, as Maurice said earlier, quite critical that you have good lawyers alongside you. It is business as usual. So the practitioner doesn't really want to have to keep going back to creditors for another vote. So it's quite important in the plan. So Ian used the example, for example, where there's a compromise. If you're going to say, we will pay you 60 cents in the rand by the end of this, you open yourself up to criticism. When you say we produce cash flow forecasts, you've all seen them, there's absolute transparency into the numbers, and we estimate a dividend of 60 cents. But this could be lower and it could be higher depending on what we do in realizing assets. And if you've done that, it allows you to continue the plan and not have to go back to the creditors merely because you realize you're only going to be able to pay them 55 cents in the rand. If there's a major change, so you thought you were going to continue trading and you thought it all was going to be well, and as like a Kodak film, your whole market goes away from you and you can't continue trading, then you're obligated to go back to the creditors and with a revised plan, if indeed there is a revised plan. obviously, if there's no revised plan, then the practitioner does have to put the company into liquidation.
Yeah, I'm just gonna deal with participation by shareholders. So just changing the topic, because there's an interesting nuance when it comes to business rescue, and that is that post business rescue, the shareholders have greater rights than pre-business rescue, and that's as a result of section 146, which, if I can, I'll call up on the screen. There we go. And you'll see here that during a business rescue, a holder of company securities, each holder of any security of the company is entitled to notice of court proceedings and decisions, meetings or other relevant events concerning the business rescue. Obviously, if you're a director, you're entitled to, well, you have those rights pre and post business rescue. Participate in any court proceedings, formally participate in the company's business rescue proceedings to the extent provided for in the chapter. There's the votes, and reject or propose the development of an alternative plan or present an offer to acquire the company's interests of any or all the creditors or other holders of the company's securities contemplated in section 153. So if you are merely a shareholder of a distressed business, you have rights to apply to court to have the business placed into business rescue, and then you have these additional rights once the company goes into rescue. Another point I'd like to make is, again, changing topic, but quite important, is directors, their duties remain, their fiduciary duties remain, and if they fall foul of the Companies Act, the consequences remain. The same applies to the business rescue practitioner. If the business rescue practitioner is nefarious for any reason, you can have the business rescue practitioner removed. Now, resigning post-business rescue does not, you won't relinquish those duties. You'll still have those duties. So it won't assist to try and run away from your obligations. And the business rescue practitioner suddenly has control over you. You become the business rescue practitioner's servant, and you have to heed to the business rescue practitioner's instructions. What I mentioned the other day, which is a good analogy, is you suddenly become a statutory employee of the business rescue practitioner. But having said that, your relationship with the business rescue practitioner is going to be a good one, because the business rescue practitioner needs to enjoy a relationship which is conducive of a rescue. So very, very different in liquidations. There's no business to rescue, so the liquidators don't care less, and there's no need for them to actually enjoy a good relationship. What they'll do is they'll just subpoena or summons you to inquiries to get the information. They don't need to be nice. Then we got a question.
Can I just say something on that? Can I just say something on that matter, on that note? So it's very important for both the business rescue practitioner to be a reasonable person and for the directors to be reasonable people when engaging with the business rescue practitioner. We are in the business of finding middle ground. Almost everything we do on a day-to-day basis is negotiating and finding a middle ground. And it is so much easier to do when you're negotiating with reasonable people. In other words, when the directors are reasonable and when the business rescue practitioner is reasonable. So reasonableness is so important. So for directors to choose a business rescue practitioner, you have to find a reasonable person. And for business rescue practitioner to take on a new business rescue, he has to be satisfied that the board of directors are reasonable people with whom he can deal. Otherwise, he'll just be bashing his head against the wall for the entire duration of the business rescue process, and it's not likely to end well.
Yeah, if you know a business rescue practitioner and you know them, you know their personality, and they're aggressive individuals, stay far, far away from them. They're short, intemperate or aggressive. That's not the type of individual you want. That's the type of individual banks would want, let's say, in a liquidation, because you want a liquidator who would not be shy when it comes to subpoenaing and extracting information to get to the bottom of the company's affairs. Sorry, I think it was Peter, you wanted to say something?
Yeah, Maurice, I mean, just in square brackets, you make an interesting point there, because do not assume that, first of all, practitioners are good business people, and secondly, they're going to behave above board. We have had a case of a business rescue practitioner who filed for personal bankruptcy, whoop-de-doo, and I've also had an experience prior to Chapter 6 where a company was in distress, and I was appointed to the board to do a turnaround. And the previous CEO had been had up for fraud. He was eventually paid a fine to the regulator, what was then the FSB, and that individual now, would you believe, is a senior business rescue practitioner. So do, if nothing else, search the individual's name on the web and ascertain which professional body they are represented by. There's the Law Society, there's the Institute of Accountants, there's SAIPRA, the insolvency practitioners. If the person's not accredited to any professional body, then it beggars the question to ask why. I was just going to pick up on the director's story. One of the interesting things that I often have to remind people of, especially in the SME space, you've got a shareholder who's a director of the company and he's lent money into the business. I always remind those individuals that they're wearing 4 hats and they've got to decide which one. They are a shareholder and then obviously have the rights as a shareholder. They're a director, they're also an employee, and then they're a creditor. So they've got all 4 things to consider. Obviously, I would argue that the director position is the most important because with that comes the fiduciary duties. But it is important to remind people that whilst they have certain rights as a director, they have very different rights as a creditor. One of the questions that I see was raised, and it is not unusual, it's about disputes between the board, but also it can be disputes between shareholders. Remember, the board has to put the vote, the idea of going into business rescue to vote. Now, under normal conditions, i.e. not when COVID's hanging over our heads, is that Section 22 of the Companies Act is important because that's the reckless trading provisions. And if a company if the board of directors are seen to be trading recklessly, then they can be held personally liable. And I remind us all, under the new Companies Act, that was board directors and senior managers. So any senior person in the company can be held personally liable for the liabilities of the company. And directors, rightly so, are very concerned about that. There is a moratorium on that just at the moment, whilst the lockdown's in place. Hence, the CEO of Edgar's, if anybody heard it, announced to the market that he wasn't going to pay anybody any monies owed in March, April, and possibly May, whilst they sort out the Edgar's situation. But the point there is, if the directors are having a discussion and it doesn't necessarily have to be a formal meeting, you're sitting around the exco table, not even all the directors, and you're discussing the fact that the company cannot pay its liabilities over the next 6 months, then be very cautious of what's documented. Because as soon as something's documented to say we are unable to do that, as Maurice rightly said, then you're obligated as a board, if it's discussion at board level, to advise creditors and all affected people. I've never read such a daft piece of legislation, because obviously if you do that and advise people that you're not going into rescue and don't advise them how you're protecting yourself as a result, well, you've just opened yourself up to a lot of liquidation applications. Now, if the directors can't agree, it is a 50% plus 1 vote. Ideally, you get all the directors on board with you, but the chairman has to put it to the vote. And once the directors have voted to go into rescue, they have to file that resolution. Normally, that resolution would include that they appoint one of their members to deal with all the company's SIPC requirements. And then an affidavit has to be signed by that individual stating broadly why it went into rescue and why the company's come to this conclusion. But it is, if there is dispute, it's 50% plus 1 of the board that needs to vote.
Can I jump in quickly? There's a good question here from Mercia, and it follows on from what Peter was saying. Can COBRA also be a mediator between directors prior to business rescue? If, for example, you have a financial director who thinks the company should go into business rescue, but your other directors think it is not necessary yet. And the answer is yes, absolutely. We've done quite a lot of that.
So that's the intention. That's the intention of the pro bono meetings with the team. Is that if you want a meeting, let's say tomorrow with COBRA, so we can have a discussion with your entire board, we'll do that, and that's effectively the mediation. It's to explain, to reach consensus at a board level, and if there's dissent to try and understand why there's dissent and to address that particular director's needs, interests, and concerns so that we can get that director on board.
Just
and obviously one of the things I would mention to the directors is obviously the liability that they may attract by not voting in favor of business rescue. If business rescue is in fact in the company's interest. Sorry, Ian.
Yes, absolutely. We were able to meet formally. We were available to meet informally, which with the various directors, whatever way would be preferable. We've got an interesting case at the moment where Peter and I obviously do a lot of business rescue work together as joint business rescue practitioners. But coincidentally, we had a company who half of the board know and trust Peter very well, and the other half of the board know me very well and trust me. And they were the two halves of the board were in a terribly acrimonious legal fight, and we've managed to bridge the gap by getting appointed as the business rescue practitioners, which also took some convincing, obviously, to the board. And now we've bridged the gap, and we're hoping that will result in a favourable outcome.
There's a question that I'd like to answer. It's, please excuse my ignorance. I know it must be annoying after all these webinars. It's not at all. We actually welcome these questions. But is it the directors or the shareholders who vote on whether or not to go into rescue? I understood that it's the shareholders. It's not the shareholders, but the shareholders can apply to court to have the company put into business rescue. So that's how the shareholders can do it, but they can't do it by way of a vote. But bear in mind that shareholders have the power to remove directors. And if they find that it's in the company's interest, or they believe it's in the company's interest, they can exercise their rights as shareholders to reconstitute the board so that a business rescue goes through. Other than that, it's the directors, 51% of the directors need to vote. Are there any other questions? We're coming to a close.
Maurice, could I just...
Really, really helpful.
Just a quick add to that on the shareholders. We mustn't forget that the creditors vote on the plan. We talk about a provisional plan being adopted because it has to go to the shareholders as well for vote, only if the plan affects their rights. So if the rights of the shareholders, so you haven't changed the equity structure, you haven't messed with the securities that the shareholders hold, then you don't need their vote. So it's an important point. The directors put it into rescue, and then the creditors vote on the plan, not the shareholders.
Yeah, quite correct. There's another question. Can it be agreed that one creditor also be a super preferential creditor over the other creditors? I'll throw that to the engaged guys.
Yeah, look, this is a common thing that people sort of say, well, can't you just pay me because I'm secured, or there's some other reason? We draw a line in the sand. Everything on the back of that line, so pre-rescue, is frozen. You cannot prefer one creditor over another. However, you obviously have to negotiate with your critical suppliers to continue the business, if the rescue plan is to continue the business. So now you're in negotiation with your suppliers. Well, you can imagine that negotiation calls for you to consider the balance that was owed at the date of rescue. So what a lot of the practitioners will do is try and soften the blow for their critical creditors. But that amount that was owed, if you owed them 10 million on the day of rescue, you cannot reduce that amount. But you can, for example, pay them slightly more for your product and keep that money aside, so that the point at which the rescue is successful is a fund, if you like, to pay that creditor. I mean, that's just one example. There are numerous ways to accommodate the creditor. But the creditor's only preferent for any suppliers post-rescue. And preferent, if the credit happened to be secured, normally the bank's pre-rescue, then that, as I said earlier, that security doesn't change. Post-rescue, they almost super preferent on that particular piece of security. So if they have a mortgage and they've continued funding under the mortgage agreement to the company, that portion that they gave PCF will be paid out first, and then obviously the second part will be the amount owed under the mortgage originally, if it realizes sufficient to repay them.
I've just pulled up on who can apply to court. It's not only a shareholder or creditor, but it's also a registered trade union. or representing the employees, or any of the employees of the company not represented, each of those employees and the respective representatives have the right to apply to court. But it's only the directors who can resolve. And it's in terms of 129 here, you'll see that you cannot resolve as such if there's a liquidation proceedings have been initiated against the company. So it's important to get in there before service of a liquidation application. Otherwise, what happens is you have to counter apply in the court proceedings for business rescue, and the resolution has no effect until it's filed. And I think that's really it. I think that's it for questions. We don't have any more. There's any comments that the panelists want to add? Is there anything I've missed out?
I just want to add to that last question, Maurice. The question specifically says, can it be agreed that one creditor also be a super preferential creditor over the other creditors? So, I mean, it is, the Act does clearly spell out which creditors fall into which classes, you know, who is secured, who is unsecured, you know, who is preference, etc., etc. So, if the question means within one class of creditors, for example, within a class of unsecured creditors, can it be agreed that one of those creditors is super preferential over the other creditors? Now, my answer off the bat would be no, because we've got to be very, very careful not to be favoring some creditors over other creditors. So, so as a rule of thumb, no. As Peter suggested, there is, unless there's a very, very good reason why we should do that. You know, if it's a supplier of goods or services that are critical to allow the company to carry on functioning, then we may have to do that. But ultimately, that should be, if that is the intention and if that is the only way to move forward, then that should be included in the business rescue plan and should be voted on by creditors as per section 152 of the Act.
Great, thank you very much. Thanks to the panelists. I'd ask the audience, please, if you can, we want as many people in the COBRA ecosystem as possible so that we can negotiate those debtor-creditor relationships. So if you can, on social media, let people know about these webinars, bring them in, let them know what we're about, and the fact that we're pro bono. This is one occasion where you can get all this advice and not have to pay thousands per hour to an attorney. So thank you very much. Please join us tomorrow for a refresh. Otherwise, every day at 10 o'clock, we'll be on this webinar and it'll be the same link. Great. Thanks, guys. Thank you, everyone. Bye-bye.
Thanks.
Thank you.